What?
Behind you.
You watching me?
I am.
Uh-oh. Keep an eye on you guys. You guys have to leave me alone.
Well, I'm gonna turn around and watch you.
That's a good idea. It'd be something.
Meeting will resume, and we're on a work session. Number 99, LD 991. And we want to invite up Dr. Hanson. Dr. Hanson, would you be willing to come up? Okay. Dr. Hanson, normally people have 3 minutes to testify, and I think you were held to that last time that we were here. But
Well, I was told I had just come up to answer questions, so I didn't really prepare anything, but I'm willing to answer any questions. One thing I should point out, though, before we start is you might not know this, but yesterday the plaintiffs have appealed the case to the Second Circuit Court in New York.
I was going to ask Dr. Wright if he knew if there would be any appeals, so that doesn't surprise me.
That happened last night.
Okay. And it is correct that we want to ask you some questions if you're willing to answer them.
Absolutely.
And I'm going to set here's the parameters. It's going to be set at 10 minutes. In 10 minutes, you can answer just one question, or however you want to do it. If you would like more people to ask questions, maybe you need to shorten the answer a little bit, but you will have 10 minutes to it. And then it will be stopped, because folks sitting here know that when the time is up, the time is up. Okay? So we'll proceed.
More time this time than we did last time.
I didn't hear. Are there any questions from the committee for Dr. Hanson? House Chair.
Thank you, Mr. Chair. I actually was wondering if you had an opinion on the questions that Representative Chapman asked our analysts before we took a break.
Yes, that's the preemption issue. The way that generally works is if the federal government passes a law such as what's called the Pompeo bill, it expressly prohibits states from taking action. Now, they can't retroactively preempt a state from taking action. So the question would be has Maine's law been implemented or not? So, for example, since Vermont passed their law, regardless of whether Pompeo goes into effect, Vermont still can do what they're doing. It's an open question about Maine and Connecticut, because you both pass laws, but they have these triggers. I suspect that they would not be preempted, but I would have to check on that.
Representative Hickman? And actually, I'll try to space out the questions with folks, but so just indicate that you have a question. Go ahead, Representative Hickman.
Speaking of the trigger, the federal constitution says that states shall not enter into compacts with other states. Would you consider the trigger a compact, or is it defined differently?
I would have to check, but it seems to me that you're sort of doing a compact with other states, but it's unclear whether they've been named or not. Maine, you just say 5. They must all be contiguous. Connecticut said there had to be 4 other states, and 2 had to touch Connecticut. So,
Okay.
They're contiguous, but the 2 have to touch just specific to Connecticut.
yes, so of the 4 other ones, 2 have to touch Connecticut. That's and Connecticut also said, and the states that pass these, among these 5, they have to have a population exceeding 20 million people as of the census from 2010.
Representative Black.
Thank you, Mr. Chair. Thank you, Doctor, for being here. Can you help me understand this Vermont court case a little better? Or, the first one, the first proceeding, if I understand it right, is just basically a clearing ground so that they can actually get to court and sue each other? Or you know.
Well, what that, I guess the way I see what the court did is, it is true that this was just about a preliminary injunction, but when you look at what the court said, at least about the GE labeling, she was very clear that she didn't think much of the arguments of the plaintiffs. Like on the First Amendment one, she said, I don't think you have a case here, but legal minds might differ on that, and maybe if the case was more fully fleshed out, which at a trial, more data could come in. But she made it clear that on each of these cases, whether it's, you know, Commerce Clause or First Amendment rights or the preemption, that she didn't think much of the plaintiff's case. So that's why I thought what they were going to do was actually appeal it, because it seems to me clear that if they would argue the case before this judge, that they would probably lose on the GE labeling issues. At least that's what the judge made very clear in terms of what her thinking was. And I'd just like to point out on the preemption, she expressly pointed out, I'll just read this. She goes, plaintiffs also recognize that pending federal legislation, if enacted, is intended to expressly preempt state law GE disclosure requirements. This, of course, begs the question of why such legislative measures would be necessary if Act 120's GE disclosure requirement was already preempted, end quote. So she's basically telling the plaintiffs, your argument that this is preempted is the fact that there's this national law that expressly preempts the state. That works against them, because why would you need this if their case was so clear? So she's telling them on preemption and on these other things that she doesn't think much of their case, or on the First Amendment ground. She goes through various, is this political speech? No. Is it controversial? She basically says, no, not more controversial than anything else that's required to be on a label. So the judge made it very clear. So that's why our suspicion was that what was going to happen was that this would be appealed to the second district court. And if they lose there, then the only other place they could go is to the Supreme Court. But when they do that, the case as it is goes to the next district. There's not going to be any more data that comes in. It will be just on the record from this case. And I think this judge did a very good job in 84 pages of meticulously going through the arguments with lots of footnotes. And that's going to make the bar much higher for this appeals court to try to overturn. But we'll have to wait and see. And that process of that appeal, that could take 2 or 3 years or more. In the meantime, Vermont's law will go into effect.
Yep. Representative Duncan.
Thank you. Mr. Hanson, can you speak at all to the reports that came out on the glyphosate?
Yes, that's a very important decision. That was from the World Health Organization, this international agency for the research on cancer. As I said, 17 experts from all over the world from 11 different countries. 4 of them were from the 4 of them were from the U.S., and they unanimously agreed that glyphosate is a probable carcinogen. Now, you may ask, well, how come that differs from what our EPA says or what the Europeans have said about glyphosate? And the answer to that is the regulatory agencies, when they look at glyphosate, for example, they ask the question, what is the toxicity of just this compound? So that means if there's a study that has been done, for example, on humans with the actual herbicide that sprayed the full formulated product, the agencies don't consider that, because if such a study finds some problem, then you can't figure out what's causing it. But IARC, of course, did, and that was one of the reasons why they said it's a probable human carcinogen, because there's data, for example, from Colombia, where they've looked in 3 areas where there's spraying of glyphosate as part of the coca eradication program. There's a 4th area where there's aerial spraying of glyphosate for sugarcane, and then they had a 5th area where there was no aerial spraying. And they looked at the bloodstream of people from those areas, and they could see evidence of genotypic damage to the DNA. They consider those studies very important because they're done on the formulated product. There's also been studies that have been done on rodents with the formulated product. Regulatory agencies don't consider those studies because they don't speak to the narrow issue of the toxicity of just glyphosate. But from the viewpoint of a human that's exposed to it or an environment, you're exposed to the full formulated product. That's not what the agencies look at, and so when there are studies that look at the full formulated product, they tend to ignore them, which doesn't make much sense from a broader scientific sense. It does make sense if the narrow question you're asking is, what is the toxicity of glyphosate? But nobody's ever exposed just to glyphosate. You're exposed to a product, and so that's why. That's the regulatory agencies don't consider that, and IARC does. IARC basically considers all the data that has been submitted to governments or is in the published literature.
Okay, Representative Hickman, looks like it'll be the last question, and we'll get an answer if we got to take a minute to get the question out.
We've heard a lot of arguments about the cost for food manufacturers to have to do this. Do you have any opinion?
Yes, very quickly on the cost, I will leave behind. We actually did a study. Most of that Cornell study, that's the intellectual property of the Council for Biotech Information. That's based on all these assumptions. Because what they did for those studies is they assumed that if a law goes into effect, that, for example, all the ingredients will be switched out for organic or non-engineered ones, and that'll cost more money. So it's unreasonable assumptions. As we've pointed out, we hired a firm, and if you just ask the labeling question, how much would it cost, and you look at all the studies, the median value comes out to less than $1 per person per.
Well, thank you, Dr. Henson, for your coming, making the trip up, and providing some helpful information for us.
Thank you.
Representative Chapman?
Thank you, Mr. Chair. Just for the record, I'd like to say that I did have other questions, and I understand that you have a time limit, but I'm sorry that we didn't get to your questions.
If I known you had a question, I would have gotten you in on it.
No, it's fine. We'll take turns with it. I just wanted to indicate my displeasure that we put time in.
Okay, thank you. Is there any, Dr. O'Brien?
I just wanted to say one thing, that I don't disagree with what the doctor just said, but just so that the committee doesn't think that I was misleading them, what the doctor said was that the judge didn't think much of the case, and it's clear that there is stuff in the document that, or in the opinion, that sends signals, but that's not legally binding. That's dicta, and it's not really my role to cherry pick favorable statements that aren't legally binding. So I don't want to. I just wanted to make that clear that that's more of the role of an advocate than nonpartisan staff. So I just wanted to make that clear on the record.
Thank you. Any further discussion on the motion on the floor? And then all those, Ashley, Cassie, do you want to call the roll? This is just actually a. I'm not even sure if the persons that are absent can come in and vote. It's just a routine message, a vote to request that this be carried over until the second year of the 121st. 127. Representative Chapman, before we vote, you have a question?
Yes, thank you, Mr. Chair. I'm wondering if, as a committee, we have an opportunity to discuss this before we vote? There's a motion on the floor. Are we-
It's a debatable motion, yes.
Because I do have, I did want to make a comment.
Sure, go ahead.
Which is the thing that's of interest to me, and it relates to the question I was unable to ask, is that if Maine were to pass a law now, and then the federal government next year passes a law saying states can't pass laws on this topic, then our law would still be, we'd be able to do what we wanted to do. We'd be able to have the law in place. Whereas if we say, well, let's wait a year or two, and in the meantime, the federal government says, yeah, you can't do it, then we've eliminated the possibility of doing that. This issue came up in another committee and another bill that had to do the same thing, and I'd like to make an observation that government legislative activity, by necessity apparently, tends to be reactive, which means it's very hard to get proactive things done, that is to say, in a timely fashion, putting something forward that actually leads and establishes occupying the legal space that prevents the preemption things from blockading you, tends not to be the way we do things. And at the same time, it represents opportunities missed. And so that's going to influence the way I vote on carrying this over, is that I'd rather find out whether, as a legislature, we wanted to do something here, because our choice to be able to do something here may very well not exist when we come back to it later. Thank you.
Okay. Brother, I think I could answer that, but Dr. O'Brien, if we do something that's contrary to federal legislation, we're against the rule, what would happen? I think I know, but go ahead.
Well, I did run during the break, and federal law trumps state law, and so there's preemption there. There could be, and I think that this is what Representative Chapman is speaking to. I mean, the federal, they could grandfather in states that already have laws in place. I mean, the federal government can make laws that they want, and they could potentially say any laws that are currently on the books can remain. However, moving forward, I don't. That doesn't happen very often. I don't want to make it seem like that's likely or comment on whether that is potentially going to happen, but I don't want to say that it doesn't make any difference, because it could. I think it's unlikely that it would.
Do you know any legislation that's in the pipeline in these other surrounding states that would actually meet the contiguous rules?
It's my understanding that there's legislation in all of the states that are in different stages of
So that might meet the requirement that we currently have in the law that we passed last time, a year and a half ago. Representative Black.
Thank you, Mr. Chair. I was just going to relate that a little bit, that we do have a law that we passed last year on the books. And my opinion is that I would rather see this bill set aside till next session so that we can continue to work it if we so see fit to do. We don't know what the vote would be here today, and this bill could, if we just voted the bill up or down, we could, the bill might have a better chance to pass it in the second half of the session than it would in this session. So that's why I support carrying it over.
Okay, we'll vote on this bill by roll call. So, Cassie, if you would call the roll, please.
Senator Edgecombe?
Yes, on the carryover. The request for carryover information.
Representative Hickman?
I would reluctantly vote yes to carry the bill over, but given that Vermont's law could possibly go into effect before the appeal happens, is interesting, because we're voting to carry the bill over to wait to see what happens in Vermont, which again means Maine is not acting on its own. I'd rather see the bill carried over than killed, so I will take Sophie's choice on this one.
Senator Dill?
Yes, carried over.
Representative Black?
I vote yes because I'd rather see the bill carried over than killed.
Representative Duffy,
A reluctant yes.
Representative Maria,
Reluctantly, yes.
Representative New,
Another reluctant yes.
Representative Kinney,
Well, I might as well make this somewhat unanimous. Reluctantly, yes.
Representative Saucier,
Reluctantly, yes.
Representative Edgecombe, Representative Chapman,
No, and the reason is simply that if we build the bill this year, we could come back at it again at another time.
Representative McElwee.
Reluctant, yes.
That is 11 voting for the carryover, 1 against and 1 absent.
And the motion to carry over passes, and keep in mind, this will be, if the leadership tells us we can't do it, then we'll have to revisit it this year, before the session ends. Now, we have one more work session bill.
I just can't count. It's after 5 o'clock, my screen's shut down. Not on the work session.
At this time, Dr. O'Brien, we're going to do salmon sheet on 1323. Dr. O'Brien is 1326.
Great. I'll just give Cassie a moment to pass out the analysis.
The guy from New York will be almost around. Only 60 miles different.
Is it really?
Ready for me to begin?
Yes.
All right, so LD 1326, an act to require labeling of all genetically modified products. This bill does the following. Defines genetically modified products, which includes genetically engineered seed stock, products from animals fed genetically engineered food, and medicines that were manufactured with genetically engineered plants or animals, to the laws regarding the labeling of genetically engineered products. Requires the disclosure of genetic engineering of food, seed stock, products from animals fed genetically engineered food, or medicines that were manufactured with genetically engineered plants or animals beginning January 1st, 2017. Provides that food, seed stock, products from animals fed genetically engineered food, and medicines for which the disclosure is not made are considered to be misbranded and subject to the sanctions for misbranding. Removes exemptions for products produced without knowledge that the products or items used in their production were genetically engineered, animal products derived from an animal that was not genetically engineered but was fed genetically engineered food, and products with only a minimum content produced by genetic engineering. Removes the exemption from disclosure requirements as regards to restaurants, alcoholic beverages, or medical food, increases the penalties for non-disclosure and misbranding to a Class C crime for the first offense and a Class D crime for the second and subsequent offenses, and repeals the contingent effective date established by Public Law 2013, Chapter 436, Section 2, Subsection 1. And before I jump into the testimony, I did, on the blue sheet that's attached, engross what the bill does into the currently established law. So if you wanted to take a look at the highlighted sections, that's what the effect of what the law does there. if anyone has any questions about that. But I'll jump into summarizing the testimony on LD 1326. Proponents at the public hearing said we need to reclaim our food and seed sovereignty from the corporate empire before they destroy our food and farming irreversibly. The scientific evidence accumulated over 3 decades documents miscarriages, birth defects, carcinogenesis, endocrine destruction, DNA damages, general toxicity to cells, neurotoxicity, and toxicity to liver and kidney at glyphosate levels well below recommended agricultural use. There was testimony that it's not nice to fool Mother Nature. I do not wish to be a GMO guinea pig. We need to eliminate the exemption for medicines in order to protect our children, and GMOs and organic foods cannot coexist. Testimony against this bill at the public hearing stated that consumption of food products made from GMOs is safe to consume for humans and animals. The science is safe and there's no evidence to the contrary. That this action would devastate Maine's dairy industry and is completely unnecessary. That Maine already has a GMO labeling law on the books, making this legislation appear unnecessary. That this issue may be best addressed at a national or international level of regulation. This bill will have a significant department fiscal impact, including the need for new staff and equipment. There was testimony that if Maine farmers who do not know if the grain they feed their animals has been genetically altered are forced to label their products as genetically modified, this will create unfair competition. There was testimony that it would be difficult and costly for restaurants to track and label ingredients as menu items change. That this proposal would shut down the critical marketplace, causing irreparable harm to Maine's food community and the people they need, and that LD 1326 would drastically alter Maine's laws governing genetically engineered products and make it the most prohibitive law in the country, surpassing similar laws enacted in Vermont and Connecticut. Potential issues are essentially the same as that were addressed in the opinion that we were just speaking about on the last bill, except I do want to mention that this is more prohibitive, and so some of the constitutional challenges, may be addressed differently if this were challenged under the Commerce Clause, the First Amendment, and the preemption issues that we discussed. But those same issues would apply to this bill as well. And then one other thing I wanted to mention is that because this bill creates a new crime, it will need to go before the Criminal Justice and Public Safety Committee for approval as well before it's enacted. If anyone has any questions about any of that, I'm happy to answer.
Representative Black?
Thank you, Mr. Chair. I make a motion LD 1326 ought not to pass.
Is there a second?
Second.
Moved and seconded. LD 1326. 13. Ought not to pass. Cassie, let's, any debate, any discussion, any questions? Cassie will call the roll.
Senator Edgecombe?
Yes. Ought not to pass.
Senator Dill?
Yes.
Representative Hickman?
Yes.
Representative Black?
Yes.
Representative Dunphy?
Yes.
Representative Maria?
Yes.
Representative Noon?
Yes.
Representative Kinney?
Yes.
Representative Edgecombe?
Yes.
Representative Chapman?
Repeat the motion, please.
The motion ought not to pass.
On which,
On 1326.
no.
Representative McAwee?
Yes, ought not to pass.
And so Representative Chapman, your report?
On to pass.
Ought to pass.
So the motion ought not to pass carries. With all those present and voting? Excuse me, it's not unanimous. With 13, 11 to 1?
11 to 1.
11 to 1.
No.
Okay,
It's 10 to 1, yes.
Oh, yes, that's right.
And this closes the work session on 13/26. Now we have 11/83. You may proceed. Are you okay with that?
Yeah, I'm fine.
Okay. I don't know. All right. Representative Hickman, would you like the salmon sheet to be explained to us? Or we can proceed with your motion if you want.
I would like to distribute, I'm sorry, I can't see. I would like to distribute an amendment to my bill. I would like to distribute an amendment to LD 783 and then make a motion on it. Sure.
Well, it's up to you whether you'd like me to go through this now, or whether you'd like me to
I'll
hear
let
the
this-
amendment and then go.
I'll let the sponsor of the bill.
I would ask that we don't go through the salmon sheet today.
Okay.
We can go through it and we hopefully get to it again, but I would just ask for Ms. Nixon to just pass out my proposed amendment. And while she's handing it out, if the chair doesn't mind, I will just read what it says for anyone listening, and then I will make a motion. It says, Section 25, right to food. Every individual has a natural and unalienable right to acquire food for that individual's own nourishment and sustenance in all ways that do not encroach upon the rights of others, and every individual is fully responsible for the exercise of this right, which may not be infringed. And so my motion would be that we table this until later in today's session.
Okay, I understand the tabling motion, and does that have a second? But it's not debatable, but you're going to offer this amendment once we open the work session and hear the big stuff, et cetera. You just want us to have a copy of this. Okay. Again, the motion's not debatable, that we table this until later in today's session, using the terminology of the House. All those in favor? Please so indicate. And it's, I think it's unanimous. It's unanimous vote. And that motion, we got that good. I don't think we need a report from the Appropriations Committee, so the chair is open for a motion to adjourn. So moved. So moved. Do I hear second? Second. It's moved and seconded to adjourn. All those in favor, so indicate.
I got that. He's got this one. It's all over.
I'll let you know.